Good afternoon. And apologies for starting a little bit late. We switched rooms on our wonderful support staff who do the tech part of this, and so we had to do a little bit of a scramble here. It is my annual pleasure to welcome people to the annual Valerie Gordon Human Rights Lecture at Northeastern University School of Law, and this is our 17th annual lecture. And today we welcome Professor Rajagopal from MIT to talk about legalizing social rights. This law school community has a deep commitment to social justice and to a thoughtful and serious discussion of how we further human rights both locally and globally. And this lectureship is an important part of this commitment. The lecture itself is named for Valerie Gordon, a 1993 graduate of Northeastern who in her short life was a tireless activist for human rights. While here, she was the main force behind a student of color coalition that permanently changed the landscape of this school. Her dedication to people of color and the connection to human rights was inspiring for the people who knew her, who speak about her with that particular kind of fondness and awe that accompanies the memory of the truly great. We annually dedicate this lecture to Valerie and welcome into our community her family, many of whom carry on her passion for justice and for advancing the human and civil rights of marginalized peoples. Today, Chris Lamar, her partner and classmate, and also her husband, was unable to join us. Chris is now carrying on her and our human rights mission as a highly regarded anti-death penalty advocate at Capitol Defenders in Atlanta, Georgia. We are, however, today joined by Valerie and Chris's son, Feluke Gordon Lamar, and he will be saying a few words at the end of this program. And also by Valerie's sister, the Reverend Dr. Carolyn Gordon, a dynamic minister and professor in her own right, who will also say a few words at the close of the program. And by Valerie's cousin, Bernice, a civil and human rights activist, and her husband, Arthur Pulley, the oldest living African-American graduate of Yale Law School. Please join me in welcoming Valerie's family, who come every year for this important event. A few years ago, this lecture became part of a larger program on human rights and the global economy, housed at this law school, and as of last year, funded by the Ford Foundation. In the last few years, the program has become a critical part of the work that we do, both domestically within the United States and internationally. And if you're interested in hearing more, please seek out one of the co-directors of that program, Martha Davis, Margaret Wu, Dan Danielson, or Lucy Williams. In addition to welcoming a speaker who is known for human rights scholarship and activism at this annual event, part of our tradition is the presentation of the Spirit of Valerie Gordon Book Award by the Black Law Students Association. This year, I understand, instead of presenting an individual award, no. Okay, I'll leave this to you, actually. After the BALSA presentation, Professor Dan Danielson will introduce our featured speaker, and he will lead us also in the questions and answers. And after that, please wait so that we can hear from Dr. Gordon and Feluke. I'd like to ask Patrice Dixon to come to the podium to introduce the BALSA part of the program.
Good afternoon to the Gordon family, or keynote speaker, Mr. Rajagopal, faculty, students, and staff. It is a pleasure to announce this year's winner of the Spirit of Valerie Gordon Book Award. Valerie Gordon, a graduate of Northeastern University School of Law's class of 1993, was a very important member of the Northeastern community. Her background in journalism set her apart from her classmates. An outspoken and active member of the Third World Coalition, Valerie Gordon helped to keep pressure on the law school to increase diversity in student enrollment and faculty hiring. In addition, Valerie Gordon was active in the fight for international, domestic, and local human rights. Shortly after graduation and the delivery of her first and only child, Valerie Gordon passed away. After her untimely death, however, her family received notice that she passed the Massachusetts bar exam, which she took during the end of her pregnancy. Subsequently, the Office of the Dean, with the support of Dean David Hall, decided to offer a book award in the amount of $500 to honor each first-year member of the Black Law Students Association Kemet chapter. This award is an honor reserved only for first-year Kemet chapter members who submits the best essay in a writing competition. In general, this competition provides first-year members with an opportunity to delve in the rigors of legal writing and analysis and be honored for having written the best essay on a topic selected by the BALSA Executive Board. Now, the topic generally surrounds issues pertaining to African American lawyers as well as law students. In keeping with Valerie Gordon's activism for domestic and international human rights activism, this year, the BALSA leadership decided to focus on the civil rights issues that affect the Black community as a result of urbanization and gentrification, and extending a similar analysis to similar human rights issues occurring internationally in developing countries. Following a careful review of essays that were submitted, the leadership decided that only one essay stood out as meeting, if not exceeding, the requirements for this year's competition. And it's my pleasure to introduce the award, the recipient of the award-winning essay, Bama Prega Julius. Bama Prega, on behalf of the BALSA leadership, I present you with this year's Spirit of Valerie Gordon Book Award. This award is an indication of how outstanding your essay was, and also that you have an extremely bright future ahead. And in keeping with tradition, we'd like for you to share with us exactly why you chose the particular topic that you did, and also share with us an excerpt of your essay. Thank you.
Thank you. Good afternoon. First, I would like to thank a couple of professors that helped me to develop this, Professor Dao Chan and Professor Bauman, for helping me to get what I believe is something that we forget about in America. And coming from an African background, a Nigerian background, human rights is something I've always had to think about. So, to begin, I was presented with this problem of solving or figuring out what rights do we have in this country to protect against displacement and gentrification. First thoughts that come to mind is, I'm from Harlem, and in recent times, gentrification has happened in my background, my neighborhood, my world. It's something that I've seen every day for the past couple of years. In urbanization, I've witnessed in my home, Nigeria, the Nigerian Delta with the oil industries. And it's something that I've had to figure out, what rights are there to protect against these issues? First is, we have to understand that cities change, people change, everything changes. But to what extent is this change something that we should control and something we should protect against? So displacement happens as a result of change. You have to understand that with this change, people come to move and find new ways of life, but you need to protect something. You have to figure out what that something is. Through exploring different aspects of the issue of gentrification and displacement, I figured out one of those things, or two of those things, are culture, the idea of community, and also being able to live in a place where you can call it home for real. And that's the idea of housing. Do we have a right to housing? Exploring the different rights here, there are two levels of rights. There are civil rights and there are human rights. Civil rights, as we know, our Constitution doesn't extend rights but to property owners, which doesn't protect tenants, which is mostly Harlem. And the statutes that have come to fill in this gap to protect tenant rights really only protect rent-controlled housing and housing in which the federal government has a hand in developing and funding. So there are not that many rights that protect tenants who are at the whim of private selling of their homes and evictions. Within Nigeria, infamous for human rights violations, actually, as I was writing this essay, I got a call from my mother that my cousin was killed and my grandfather had to pay 10,000 US dollars or 100,000 naira to get the body from the police because they wouldn't release the body to the family. And it's just interesting how we as Americans try to set a standard to the undeveloped world as to how to act, but we don't embrace the minimal human rights. We don't embrace how is it that you protect life and liberty for real and not just like in some ways. So at first I was like, okay, what are some things we can do to protect these rights and to kind of expand our legal doctrine to include culture and the right to living and having a home in which you can participate in society. I tried basic legal doctrines such as set-asides and expanding that. Set-asides are a tax break to developers in which they develop more affordable housing in private condominiums or homes, or linkage programs where developers donate more money to neighborhoods in which they create new multi-income areas, and eviction-free zones, which is more of a grassroots movement that uses the warranty of habitability to like stave off eviction of tenants, some of which are explored in my essay. And neighborhood preservation, preserving culture like the look and feel of neighborhoods, and zoning, inclusionary zoning, figuring out how are we going to include the people within the neighborhoods to like protect who lives there and also to include others from outside of the neighborhood. At the end of this essay, I explore human rights and what that means. Here in America, we think of like capitalism, that property is supposed to be something that's privately controlled and that we have no say in it, and if you don't have any money, you don't have property, and that's the end of it. And we understand it, we accept it, but we need to question why we accept it. And these housing rights, housing should be thought of more as like a basis for community and a basis for society, and trying to extend a fundamental right towards that. I have a quote from a sentence in my essay that housing has a special character, not only because it consumes such a large portion of household budget, especially for low-income families, but because it is the central setting for so much of one's personal and family life, as well as the locus of mobility, opportunities, access to community resources, and societal status. Housing rights, as other constitutions have extended, doesn't mean that the state has to give everyone a house to live in or that that housing has to be free. What it means is giving people the recourse and the dialogue and the ability to question the housing they have and to make improvements of it And we shouldn't be so comfortable with the fact that if you pay less money to live somewhere, then you deserve the housing you have. And at the heart of the matter, although culture is not a commodity in America, it's a commodity everywhere else, but not here in America, we protect this right to housing and protect this right to live somewhere. Culture can be protected because if the family is allowed to practice within their home, they can be cultural and they share that cultural and engage in the cultural community a lot better. So in summary, I just want this room or everyone to get from my essay that yes, we change and displacement happens. It's a result of a lot of things, but there are things that we should take value in, and that's in life and people and opportunities and culture, because those are things you can't replace. So, thank you.
Thank you, Amafrega, for that inspiring speech. Also, it was an unbelievably powerful and eloquent attempt to merge domestic and international law, which is not an easy thing to do, and you should be very proud. It's now my great pleasure to introduce our Professor Balakrishnan Rajagopal, who will deliver this 17th Valerie Gordon Human Rights Lecture. Professor Rajagopal is an Associate Professor of Law and Development and Director of the Program on Human Rights and Justice at MIT. He's been a member of the Executive Council and the Executive Committee of the American Society of International Law and is currently on the Asia Advisory Board of Human Rights Watch, the International Advisory Committee of the Robert F. Kennedy Memorial Center for Human Rights, and the International Rights Advocates. He received his interdisciplinary doctorate in law, his SJD, from Harvard Law School after obtaining his first law degree in India. He served for many years with the United Nations High Commission for Human Rights in Cambodia. He has also consulted with the World Commission on Dams, the UN Development Program, and many other UN agencies, international organizations, and leading NGOs on human rights issues and on international legal issues. He's published numerous scholarly articles in many of the leading law journals, and he's the author of 2 books, International Law from Below, Development, Social Movements, and Third World Resistance, which I understand has been translated into Spanish, has also been published in South Asia, and is soon to be coming out with a 2nd edition. And he's also published a 2nd book, Reshaping Justice, International Law and the Third World. If that's not enough, he's currently finishing a book on the legalization of social and economic rights in the Global South, which is his topic for today. Professor Rajagopal, or Raj as he's more commonly referred to by his friends, seems a particularly apt choice to deliver this year's Valerie Gordon Lecture. This is because in both his scholarship and his activism, he's always explored the promise and the limits of human rights as they function in the political, legal, and organizing work of the groups and social movements trying to use them. For Raj, human rights are useful to the extent they provide tools for disenfranchised, disempowered, or subordinated peoples to assert their social, economic, and political autonomy, to resist, as Raj puts it, from below. At this thrilling and terrifying moment, where we're witnessing across the globe the emergence of popular resistance movements from Egypt to Wisconsin, movements of ordinary people expressing their deep dissatisfaction with the political disenfranchisement, the lack of economic opportunity, and increasing income inequality, for them has characterized the last 30 years of neoliberal globalization. In this incredibly fraught and also exciting context, Professor Rajagopal's message seems more important and perhaps more prescient than ever. Professor Rajagopal will speak to us today on legalizing social rights, experience from the Global South. Raj, the floor is yours.
Thank you very much, Dan. It's always a pleasure to be back among friends, and particularly here where there are so many of the people that I know and admire whose work I've read and learned from over the years. So it's not only a delight, of course, it's an honor for me to be here to deliver this distinguished lecture. And I thank the family of Valerie Gordon and the Dean and the Black Law Students Association, as well as the faculty and the students for inviting me to give this lecture and giving me a chance to share some of my ongoing work. As Dan put it, I decided to use this opportunity to kind of do an advanced version of some of the work that I'm doing in this forthcoming book. So I was delighted particularly to discover that the topic of what I'm going to address today also seems to be so timely, not only globally, but particularly in the light of the wonderful essay that we just heard. It's certainly on that very topic. So, my main argument draws on my forthcoming book with a very similar title and can be summarized as follows. Legalization of social rights accomplished through new constitutional arrangements in the form of new rights and new institutions empowered to enforce them, such as constitutional courts, do not necessarily lead to pro-poor outcomes. Though legalization of social rights can sometimes assist the poor, the ways in which it does so and the frequency with which it happens depend on many other reforms happening together, including, especially in the domains of private law of property and contract, constitutional distribution of power between varying levels of governance, as well as the economic policy in areas that are key for the improvement of the conditions of the poor. I investigated several questions related to this thesis by examining legalization of social rights in 3 large southern market democracies, India, Brazil, and South Africa. The focus is largely on housing rights in the context of urban areas and land rights in the context of rural areas. The former is the most significant issue for the urban poor in rapidly growing regions of the world, while the latter remains the most salient survival issue for the rural population, which is often landless. During the last 2 decades, the global consensus has emerged on what I would call as the legalization of the social. The chief means through which this has been done is in the form of new constitutions with bills of rights containing social rights, and in many cases accompanied by the establishment of constitutional courts empowered to enforce them. The emerging policy consensus seems to be that legalization and judicialization, that is, looking to the judiciary as the leading state mechanism for the realization of legal norms of social rights, will bail out the losers of globalization and prevent a serious backlash to business as usual tactics of marketization and liberalization, which are often offered as the tools to achieve development. If this is true, will a right to housing work better than current approaches to housing improvement and delivery? And if so, under what conditions? Many international development agencies are now pinning their hopes on socioeconomic rights, inspired in most cases by the example of South Africa, where the courts have been seen to play a major role in assuring social protections for the poor, based in large part on strong constitutional protections. Such hopes in the legalization of social rights exist, despite the lack of very convincing evidence that such court-based strategies have actually made the poor better off. Similarly, in India, rights-based approach to development policy seems to be the current orthodoxy, heavily relying on legal articulation of social rights as the principal way to bring about pro-poor development outcomes. In this talk, I seek to shine some light on this easy consensus. This legalization of the social has occurred due to several converging beliefs about the virtue of legalizing social rights. Institutional economists have put forward the idea that the introduction of formal property rights backed by independent courts will lead to economic growth and poverty alleviation. Development planning literature also largely agrees that formalization of legal rights, for example in the area of housing, will benefit the poor. Constitutional law scholars have advocated the introduction of bills of rights backed by judicial review as part of a worldwide move towards constitutional democracy. International human rights lawyers have advocated the inclusion of social rights in domestic legal systems and their enforcement by courts as cutting-edge progressive strategy. The centrality of courts in this move towards the legalization of the social has been noted and critiqued for its untested and abstract set of assumptions about the benevolent nature of legalizing and court-centrism. The critiques of judicialization of politics have called for, among other in the United States, for popular constitutionalism to taking the Constitution away from courts. On the other side, proponents of human rights and constitutional democracy have generally welcomed the globalization of judicial review and have even postulated notions of world constitutionalism and judicial globalization. My work is a critical contribution to this literature. In contrast to the largely negative literature which dismisses the role of legalization and courts, and to the largely euphoric literature which accepts courts and legalization of social rights as an unmitigated good, my work offers an account of the conditions under which legalization and judicialization can in fact lead to regressive or progressive outcomes for the poor. I will hypothesize that political ideology in the form of pro-poor policies of the political branches, the history of state-making and social movement action outside the legal system significantly affect the extent to which courts help transform social rights from law to reality. Arguments in the literature for legalizing social rights and the corresponding rise of judicial power do not typically concern themselves with these factors. Instead, they tend to focus on evolutionary reasons. For example, the movement to courts resulted from the movement from dictatorship to democracy and to human rights, or systemic reasons, which emphasize conflict between different branches of government or other traditional political actors, or the rise of supranational law, as in the context of EU, or on strategic reasons, that is, that other political actors find it convenient to legalize the social and to have the judiciary shoulder the burden for redistributive policies which are politically risky, especially at times of deep economic transitions. Or they point to hegemonic reasons, as when a set of elites acts to increase judicial power in order to protect their position and interest. These explanations do not concern themselves with the political ideology of the state itself, whether it is capitalist, socialist, or mixed or other form, the history of state making, in which dominant actors involved in state making, such as independence or pro-democracy movements, turn out to have complex socio-economic backgrounds consisting of actors drawn from many classes, and the courts emerge as actors, ambivalent actors in governance, or the tradition of contention through social movements which exist outside of the legal system and which come into conflict often with that system. In my account, I stress these as key factors behind the question of how, if at all, judicialization and legalization of social rights can actually benefit the poor. It is not my argument that they cannot, but that there are very specific circumstances under which they seem to. My work is also an attempt to address many lacunae in the various interacting strands of literature mentioned above, and offers a new theoretical perspective on the legalization of social rights in the global context. A first lacuna in this literature is the biased sample of material on which it draws, in which courts and societies analyzed are invariably from the North, and especially that of the United States. To the extent that the South is considered, South Africa finds a prominent place these days, but not always. The biased nature of this sample in turn skews the analysis towards conclusions that rest on assumptions which do not apply to majority of the countries of the world, which are in Asia, Africa, and Latin America. A second lacuna in the literature is its exclusive focus on institutions, such as courts, legislatures, and governments, to the exclusion of actors, non-institutional actors, such as social movements, who function in non-institutional arenas and only intersect with institutional politics as and when necessary. Indeed, given that most poor people in the South live in non-institutional spaces, such as, for example, the space of informality, often in degrees of illegality, such as the urban poor, this is a surprising omission. Even in literature that calls for popular constitutionalism, for example, there are rarely calls for examining social movements as interpretive communities through law, which acquires its meaning in lived reality. While there is an emerging literature on American constitutional law and its intersection with social movements, that literature is not comparative, and certainly not drawn on countries of the South adequately. A third lacuna is the focus of the literature on a single legal system, such as that of the US, or predominantly similar systems, say mostly common law systems. In addition, there is a tendency to focus on public law aspects to the entire neglect of private law, as well as a focus on domestic law to the neglect of international and other transnational sources of law. While there are exceptions to this, the narrowness of these approaches render most analysis inapplicable to most contexts other than the one being studied. In contrast, I propose to draw on the idea of law as a semi-autonomous social field, to take the well-known notion of Sally Fork Moore, in which global, national, and local legal norms coexist and interact in complex ways in both public and private law fields, characterized by what I and others have referred to earlier as global legal pluralism. The nature of this plural interaction is missed in much of the literature because they tend to tell the story from only one side at a given time, from that of the domestic judiciary, or from that of the global human rights advocacy perspective, or from that of comparative law, etc. Instead, my work offers a new theoretical perspective which can best be described as a comparativist transnationalism, in which the interaction between law and social reality can be empirically framed through the law and social movements interface. In the book version of my work, I begin with an introduction which explains the purpose and outline, the methodology of research, and the various literatures which attempt to explain the rise of social rights and judicial power. This is followed by a chapter discussing the legalization of the social, in which I describe the rise of the phenomenon and what I consider to be the reasons for the rise. While discussing the various literatures, I draw attention to the historical aspects and the doctrinal debates. The rise of the social is traced from the European experience of the 19th century, the US experience in the 20th, the Latin American constitutional experiments of the early 20th century, and the Asian and African constitutional and political experiments at the end of formal colonialism and the birth of nation building. I point out that the move towards legalization of social rights and the rise of a powerful judiciary did not always coincide. The latter must, I suggest, be seen as a consequence of many other factors, such as that of globalization of law, of institutions, especially of international human rights, as well as international development theories about institutions and the importance of institutions for economic growth, on the one hand, and of the domestic political consequences of state-making processes, on the other, which differ quite radically from state to state. I then move on to discuss the constraints and limits on the legalization of the social, in contrast to dominant conceptions which emphasize the limits imposed by the nature and function of judicial review in a democracy and the limits on judges as they deal with social questions. My account emphasizes other factors also. A set of limits arise from the institutional legacy and environment, chiefly from the continuation of colonial legal systems, particularly in countries of the South that I studied. Constitutional design and structure, the place of property rights in that scheme, the developmental role of the state, and the global legal and policy environment at particular moments of nation building all seem to have a major impact on the legalization of the social. Another set of constraints arise from the history of state making and its relation to the social, and of the role of particular classes in the making of the state at particular moments. To take one example, Brazil, for example, the particular composition of social classes that were mixed in the transformations of the 1960s that witnessed the rise of military regime, in turn led to a valorization of particular forms of legal interventions and legal reforms, which de-emphasized, for example, the rural land question for almost 20 years until it was forcibly put back on the agenda as a result of complex social actors working together from the late 70s. In the end, resulting in the constitutional reforms of the 1980s, which inevitably posed the question of property rights as the key to social justice and economic justice. Those are two different issues in Brazil, especially by the re-articulation of an older idea that property has a social function. And that notion has been creatively used by social movements to advance progressive economic and social strategies that the state itself commits itself to, but seems unable to carry them out for a variety of different reasons. So it's that little nudge and a push that actors from below can give to the state itself. For example, occupation strategies adopted by movements have pushed the state to live up to its promise that it will carry out rural land reform. And they have been able to do so, partly relying on the idea that ownership of land does not settle the issue. We need to ask a bigger question about whether the land is being socially useful. Is there a social purpose? And if so, how does one define social purpose? Has been a big issue in Brazil. And courts have also, though not always readily, but I will explain that in the case of Brazil, they have structural constraints for the involvement of the judiciary in social rights litigation, much more than that of Brazil or of South Africa or India. But even there, you find amazing examples of particular moments when the moments of state making, when the courts have been able to play a progressive role. Another set of constraints arise from the difficult relationship between law and social movements and the socio-economic composition of the judiciary. This is a structural issue that one can see in all these countries. Social movements in general are somewhat averse to using legal channels and relying on judges to bring about change, partly because of their inherent suspicion of the judiciary as a conservative institution, and partly because of the expense and the cost and the complexities and the uncertainty of approaching courts to bring about change. It is also the case that in all the three countries, the question of the composition of the judiciary has become a major issue, some less so in others. Judiciary is even today, by and large, drawn from social sections which reflect the inherent biases in society. They tend to be, for example, characterized by a large degree of, discrimination against women and minorities, and also against others who are traditionally excluded from the political structures of the state. We find evidence, for example, in the case, to give one example, in the case of India, if you take the judges of the Supreme Court all the way from independence in 1947 to 2007 or 8, until after that data is not available, more than 90% of the judges come from what you would call as forward castes. There are hardly any women on the court, except for token representations of one or two. Representation by religious groups, other minority groups, is very sporadic. It's all over the place. That in turn has begun to have an impact on the way in which judiciary is perceived in society. A final set of constraints arise from within the legal discourse itself, both in terms of the limits imposed by the conceptualization of social rights, the relationship between private law of property and contract to constitutional and administrative law principles and judicial reasoning, as well as by the techniques of judging, which has a conservative and deeply anti-redistributive tendency, as many scholars have argued, including scholars some here. The conceptualization of social rights, especially drawn from the international human rights discourse, which is the dominant model of social rights in the field, as can be seen in the case of South Africa most prominently, suffers from severe limits due to its oscillation between two extremes, between state capacity to provide social rights on the one hand, and market choice under the culture or ideology of consumerism on the other. I argued in this that, as I have argued before, that an analysis of legalization of the social in the South must take these into account. Indeed, a model of social rights that oscillates between these two extremes of state capacity and market choice is unlikely to be a progressive strategy. Just for the sake of sounding progressive, one can support the idea of social rights, but one needs to be very careful about the way in which they are articulated. If they oscillate between these two extremes, they are more likely to lead to cosmetic results. Throughout this work, I weave in lessons from case studies drawn from 3 countries, the ones that I spent time researching and looking at: India, South Africa, and Brazil. With respect to India, I offer a discussion of relevant political and legal history, including the struggle over property rights, which was one of the first constitutional struggles between the judiciary and the legislature right after independence, and extended all the way through to the 1970s, then settling into an uneasy truce. The uneasy truce has not mattered much since the fundamental economic policy direction of the state changed from the early 80s. So I offer a discussion of relevant political and legal history, including the struggle over property rights, and offer 2 examples of social movements whose encounter with the social has had to be negotiated through a maze of laws at multiple levels, from the local, informal, to the global. One draws on the housing rights movement in 2 cities, in Mumbai and Delhi, and outlines a progressive deterioration of the housing rights of the poor in these cities, especially the urban poor in these cities in today's India, in which the judiciary has unfortunately played a largely regrettable role, which may come as a surprise to many, as often India and the Indian judiciary's treatment of housing rights is often held up as a good, if an early example of a progressive approach to the legal articulation of social rights, particularly in the housing area. But a closer look at what exactly is going on, especially in terms of the relationship between housing rights movement and the judiciary in these cities, reveals something else, that in fact the story on housing rights in these cities can be bookended usefully between the famous pavement dwellers case, or the Olga Tellis case in 1985-86, which proclaimed famously that the pavement dwellers have a right to livelihood, which is part of right to life under Article 21 of the Indian Constitution, reinterpreting the idea of life to include other things than simply mere bare life. I believe the story can be bookended between that rather progressive within quotes, because again, if you look closely at Olga Tellis and its actual, language and its the the reasoning and the judicial order and the relationship between that and the housing rights movement, a much more complicated picture emerges rather than this picture which often we get from international human rights textbooks, that Olga Tellez was this shining moment, unambiguously. But I believe the story can be bookended between that case, 1985-86, a case celebrated all over the world for its pro-poor language, if not its result, and the Almitra Patel case in 2000, in which the Supreme Court infamously declared, rewarding an encroacher on public land with free alternate site is like giving a reward to a pickpocket. The other case draws on the Narmada Valley struggle for land, on the issue of land rights, and the Narmada series of cases. There have been a series of cases since the first involvement by the courts in the late 80s, and particularly escalating from the early 90s, from 93 onwards to an important order in 2000, and then other subsequent judicial orders. I then offered a study of Brazil, and again, after relevant political and legal history, offered two examples of social movement encounters with the social, which is once again positioned on the intersection between public and private law, and from local to global actors. The first discusses the right to the city movement, with its roots in housing rights advocacy for the poor, which resulted in the right to the city statute, the creation of a new ministry of cities in the government of Lula, and a transnational movement. While the second example relates to the landless workers movement, MST, and MST's encounter with the legal system and its land occupation tactic as a social rights strategy. Finally, the focus turns to South Africa, and after a short history of recent political and legal changes, it discusses two movements: the housing rights movement, especially through and after the famous Grootboom judgment of the Constitutional Court in 2000, and extending to recent cases, such as Joe Slavo, and the land rights struggle, as illuminated through another decision of the Constitutional Court in the famous Richter's Well case in 2003, and the recent communal land rights judgment. In all three countries, as representative samples of the global South, there are many common elements to the social rights story. All three countries witness strong tensions between constitutional norms and private law, as in the Fazenda Primavera case in Brazil, or the Joe Slavo case, for example, in South Africa. A more conducive atmosphere for realization of social rights when there is social movement mobilization, which combines with an ideologically sympathetic judiciary. And the sympathies of the judiciary itself largely attuned to periods of the ideological orientation of the state-making process and of economic transformation. The judiciary seems to follow the overall economic policy direction and the economic ideology of transformation of the state. A role for the judiciary which cannot be explained by looking at the judiciary either as a purely dispute resolution process or as a court of justice, but rather as an organ of governance. The notion of the judiciary as just yet another state institution, which is involved in the administration of the overall direction and the ideology of the state, and which therefore shares the biases that are inherent in the very process of governance, is an important lesson that comes out. But there are also significant differences between these countries in the way in which judicialization of politics of rights plays out in the three, including some of the following: the composition of the courts. Again, a very different story in three countries. The organization of courts and the procedures of decision-making in private law or constitutional cases. As is well known, the question of access to courts on constitutional grounds, say on right to housing, is a completely different story in India rather than, for example, in Brazil. India, with its tradition of public interest litigation and the relaxation of the rules of locus standi to allow people who are affected, and even those who speak up on behalf of others who get affected, to come before the court. On the other hand, Brazil has some of the most strict rules when it comes to standing. On the other hand, the very fact that access to courts is easier in one country has not meant that the legalization of social rights has actually yielded more progressive pro-poor outcomes in India as opposed to Brazil. In fact, surprisingly, it turns out that the housing rights strategy in Brazil has, especially in the last 10 years, yielded far more progressive outcomes in Brazil as opposed to India. One must then question the consensus, especially in India these days, of a reliance on a rights-based strategy to development. The procedure, besides the procedures and organization of the courts in private law and constitutional cases, there is also the issue of the nature of the federal-state relations, the relationship, the allocation of power between the branches of government under the Constitution has tremendously different impacts on adjudication of cases. To take one example, again, in Brazil, agrarian reform is a federal subject. On the other hand, land is a state subject. One would think that both are interconnected. But on the other hand, the disconnect between the two creates all sorts of problems and differences in the way in which courts actually are able to intervene to make changes. The nature, besides the nature of federal-state relations and the allocation of responsibilities, the level of penetration of international law into domestic law also seems to vary quite dramatically in the three countries. Again, South Africa is the other extreme, where the Constitution itself mandates that the courts take international law into account while interpreting cases. On the other hand, you have the other two countries where the tradition of incorporating international law into domestic law is very varied. Finally, the character of the bar and its relationship to society also is a major factor which varies quite significantly in these three countries. So I want to draw this to a conclusion so we have some time for some questions, and I see that you have some couple of other events after this, programs after this as well. So before concluding, I tried to develop in my work, as I said, a theory of comparativist transnationalism for understanding the role and function of legalization of the social and the expanded role of the judiciary as an organ of governance, not an organ of justice, in the light of the case studies and the examples. My intention is to argue that in the global South, courts are capable of delivering pro-poor outcomes that are in fact being in turn capable of being actually realized only under very specific circumstances, in which the political ideology of the state, the institutional design and the composition of the court, social movement activism outside of the law, private law reform, and a substantial reconceptualization of the rights discourse itself can all coexist. In its absence, I would conclude that the courts are a highly limited, if not often irrelevant, arena for the struggles of the poor. That'd be great.
I was wondering, first of all, whether you'd be willing to post your speech, because I found it to be very informative, and it's probably hard to discuss in such a short period of time. But I do have a question, and the question is, how do you avoid historical determinism? Because I mean, my sense of your argument is that your prescription is that focus on institution may be misplaced because it avoids the historical context of particular countries, whether there's a history of state-making and the judiciary is involved in the state-making process and so on. So the question is, as a legal reformer, my work is in China, how do you avoid historical determinism, right? Where you might enter a country where law has not had such a strong role,
Unless there is a question related to this, let me just quickly say a few words so that more people have a chance. Thank you for that, for the questions. The question of historical determinism, by which, if I think what you mean by that is that there is an inevitable teleology behind the processes of change. If you contextualize, in fact, there's the danger with context is often that you can only say what works there because it works there and nowhere else. And yes, there is a danger to context. But I also think that often theorizing about rights has the opposite problem of avoiding context and of drawing selectively on context. For example, the Olga Tellis case, drawing selectively on it. The reason why it was so popular was because in the 1980s, everybody knew India has a lot of poor people. And if courts are coming out and openly saying that poor people who live on the pavements, who anybody who goes to India can see, they do live on the pavements, actually have legal rights of some sort under a vague constitutional idea of right to life, it must be a progressive thing. It's an instinctive emotional response to a decision like that. But when you actually go into the decision itself and look at how the decision played a role, in fact, in sanctioning the removal of pavement dwellers, it was the beginning of the end for a large community that was coexisting and progressively led to the weakening of the rights of the poor in Mumbai. That's how the housing rights movement perceives it. That's a completely different take from what we get from the outside. So I think that there is a danger of getting lost in the details in some way. But I've tried, I think, I don't know how successful I've been in this. Verdict will be rendered when the book comes out. Whether we can tell a story that captures the nuances and the complexities of context, while at the same time drawing some broad lessons that tell us a large, ambitious story about structural things, about, for example, the way social rights cannot work as pro-poor strategies. And it's very important that we don't shy away from such generalized arguments, I think, as progressive scholars, because institutions that engage in or are in charge of global and national economic and social policies, they don't shy away from large arguments. And it's impossible to adequately respond to them unless we have an account that is equally weighty in some ways. The other question of legal education is also, I think, key, which has often come up, particularly in the context of South Africa, where it's been a huge discussion among legal academics there and among the legal profession itself. And I've also seen this debate emerge and become part of a national conversation in India from the time of the early 70s, when the first report on the state of legal education was compiled by a very well-known legal academic from India, Professor Upendra Baxi, and that in turn led to a series of conversations about how do we expand access to legal education to previously excluded sections of society, including those from disadvantaged, underprivileged backgrounds who would be able to enter the legal profession. And now I'm afraid that despite at least, I haven't looked at legal education as a key issue in this book itself, but my sense of the way it has worked out in these two countries, I'm less aware of how this debate has worked out in Brazil, frankly. But the way in which this particular question of legal education has worked out in South Africa and India is that, in fact, it has been exceptionally hard to figure out how best to increase representation in legal education, which in turn will lead to a representation in the bar and from the bar to the judiciary, partly because the representation of the bar in India, for example, matters mostly only at the high court level. At the lower judiciary level, they are not drawn from the bar. They are actually a professional judicial service. They get appointed as civil servants, and they write an exam, and they enter the service. And there you're talking about, a completely different set of issues about how do we expand access to underprivileged sections to government jobs. And that gets right into the larger question of affirmative action. So there is no easy answer, but I agree that it's a key issue to consider when thinking about the socioeconomic composition of the judiciary.
I was curious, between the three case studies, the countries, what you found in terms of the difference of the treatment of going from the courts, treatment of the poor, as you say, in terms of individual social rights and community social rights, for example, related to the law, in terms of standing. I mean, as hard as it is and the challenges that exist, I think, in the social area, the legalization of social rights for the individual, I think they're just that much harder when you're trying to argue as a community group. So I don't know if you touched on that. Some thoughts.
Right. Actually, it's been a big part of both the areas, the housing and particularly the land area. In the case of South Africa, the communal land rights dispute is in fact all about the right of the community. And how do you define this particular community when, in this case, what is exactly authentically indigenous was the big issue before it. In the case of, again, the Fazenda Primavera case that I referred to earlier, in Brazil, the court had to openly come out and face this issue. And in fact, it said something very remarkable. It said that here the clash is not between the property rights of the owner as an individual and the lack of any rights on the part of the individuals who have trespassed on the land. They are not individuals, it's a collective that has trespassed on the land. And it's not a trespass, because the question of what is a trespass depends on a prior determination about what is actually, whether the property itself is being held lawfully. And that, in turn, depends on whether the property has been fulfilling its social function. So the court went in that direction and finally found that, in fact, in this particular case, for a variety of reasons, the owner had not been fulfilling the social function of property, and therefore the occupation of the land by the group of people from MST was not actually a violation of law. So there are cases when courts have been able to interject themselves into the larger debate about land reform, which is actually essentially not about individual formalization of, for example, titles, but is actually about collective rights of access. And it has happened. In the three countries that I looked at, perhaps there are more interesting examples of this happening at particular moments in the case of Brazil and South Africa than in the case of India. In the case of India, it's actually been the reverse, that in fact there has been an attempt to completely delegitimize any idea that collectivities can have any rights at all. And there are many cases where this has happened, including the case of the Narmada series of cases, where the petitioners put forward the argument explicitly that we are a community and based on a variety of legal notions, including some drawn from international law, from the ILO Convention 127, drawing on that, and then relying on, incorporating that into Indian law. They argued that we actually have a right to stay on this land, and any eviction of us from our land that we were traditionally entitled to needs to at least go through procedures that are themselves constitutionally sound. And the court simply was not willing to listen to that. So,
to what extent do you think the role of the judiciary and the structure of the judiciary in supporting or opposing progressive change in socioeconomic legal norms is derivative of the powers of and the
Right. I think that's a complicated question because if you look purely at the structure of the judiciary itself, one could say that the structure of the judiciary and the powers that the judiciary have and have particularly exercised are all in all three countries a post-colonial phenomenon. Certainly the way in which the South African judiciary, which is the most recent one to undergo this transition from colonialism, the way in which the South African judiciary has undergone these changes is certainly attributable to the process set in motion through constitutional reform. In that sense, it owes the newfound powers and the procedural as well as substantive innovations to that moment. But on the other hand, the reason it's complicated is because judicial culture as a notion, the culture of decision making, as well as the culture of making decisions based on legal interpretation, they have a longer history in these three countries, and they are certainly influenced by the colonial experience to the extent that colonial era laws, for example, have had a formative influence on the way in which they thought about foundational legal notions. For example, property. In Brazil, we are always told, every time I would interview social movement actors, I would say, why don't you approach the judiciary? The first they will say, oh no, procedurally it's so hard, and of course it's true. And secondly, they would say, well, the judiciary is very conservative. I said, why do you say they're conservative now? They'll say, no, it's conservative, but they're colonial. The word conservative and colonial would often come together because they tend to see the way in which the judiciary understands, for example, the notion of property is very closely tied to the evolution of the judiciary from the time of colonialism and the departure from colonial understandings of property rights to a more progressive democratic understanding of property rights, which is based on the idea that property has a social function. And again, they would point out the reason why you find judges in Brazil much more favorable to an interpretation of a progressive understanding of property rights in particular parts of the country has to do with the difference in the struggle against colonialism in different parts of the difference in the process of state formation as modern Brazil formed itself from the colonial Brazil. For example, judges in the south, in the province of Rio Grande do Sul, typically tend to be the most progressive on many of these cases. And there is a big reason why that is the case. There is very interesting micro-level variations emerge, rather than thinking in broad terms about, oh, the Brazilian judiciary, is it progressive or regressive? Well, it turns out that there are particular parts of Brazil that are more than others. And that may have very well to do with the historical path-dependent evolution from previous institutional forms, which are colonial.
Thank you, sir. I'm always impressed and intrigued when I look again at the Charter of the United Nations and how it begins. It says, we the peoples of the United Nations. It doesn't say we the governments, the three that you've spoken of, or the 192. And on behalf of the peoples of the United Nations, on December 1, 1948, came into being perhaps one of its most significant documents, the Universal Declaration of Human Rights. And there are elucidated the goals, aspirations of people, which I feel is being worked out in a global, universal sense as people bring to the streets their aspirations and dreams. I wonder if you would comment how the Universal Declaration of Human Rights fits into the three particular countries you have studied, and I wonder if in conclusion you would comment on the inability of the United States to give full sanction and force to the Universal Declaration of Human Rights, which Eleanor Roosevelt and others were very instrumental in getting universal dissenters in passing.
UDHR is, of course, one of the most remarkable documents in the history of humanity. It's an astonishing achievement, however historically contingent it might have been, or beset by birth defects, as my friend Makau Mutua has charged it with. The fact remains that it's an extraordinary document which has inspired numerous innovations, social innovations, not just legal innovations, in the way in which people have understood their social situation and been inspired to change it for a variety of different reasons, and therefore it's a key part of the way in which all countries have experienced change, not just these three countries. But in the case of these three countries, I believe that the ideals behind the UDHR, if not the text of the UDHR itself, has played a very important role. South Africa, as I said, explicitly grounds itself in the framework of international human rights, based as it is on the so-called International Bill of Rights, UDHR, as well as the two covenants, the International Covenant on Civil and Political Rights, as well as the Covenant on Economic, Social, and Cultural Rights, and explicitly instructs its judges to pay attention to international law while interpreting cases. In India, it's had an extraordinary effect. Over the years, Indian Constitution was being drafted as the UDHR was being drafted. Many people who participated in the drafting of the Constitution had a keen eye for the ideals that were being propounded at the UN, and they drew on some of these ideals to make to draft provisions in the Constitution, which at the time when it was drafted was an extraordinarily progressive Constitution, extending voting rights for all, which in 1947 was a novelty, especially women. Many European countries didn't have full voting rights for women. Switzerland not until 1964. And it was an extraordinary document because it had a substantive vision of equality and not a procedural one, which again drew from the idea of economic, social, and cultural rights, drawn from the UDHR vision. Again, in the case of Brazil, right from the drafting of the OAS, the American Declaration of Rights and Freedoms, to the incorporation of those principles in the legal systems of these countries, I believe the ideals behind UDHR have always inspired these countries in their legal and social transformation over the years. And I could point to any number of other countries where this is key. In fact, it's one of the few things on which almost all countries can agree on, even if they agree only rhetorically. It's an important area of agreement between countries, that UDHR says something that we can all agree on. On the other hand, I also think that while law says many things on the books, there is the perpetual problem that we wrestle with all the time as legal scholars, which is the gap between the law on the books and the law in action. And I'm afraid that the story of the realization of the UDHR ideals is a much more complicated story. Countries are more willing readily to acknowledge it in theory, but in practice, the question of when they are more likely to be realized is an issue that all of us are struggling to understand. And my own work, in a small way, is trying to understand not that social rights are always good or always bad, but why is it that sometimes they can yield pro-poor outcomes, and sometimes, despite soaring rhetoric, you actually find that, in fact, what's happening on the ground is the opposite of what the courts themselves are saying. So the idea is to go down and understand law from the ground, as it were, from below, for lack of a better term. That gives us a better sense of the limits and the possibilities of ideals, such as the ones in UDHR. Now, as far as the United States' record on incorporating UDHR is concerned, I believe there is a very good book by a faculty member here called Bringing the Human Rights Home, right? which certainly outlines in greater detail than I can ever hope to about the difficulties and the problems in drawing on some of these ideals, particularly on the issues of social rights, on housing and key issues of health, for example, and increasingly, I would say, the right to organize, as we have seen in Wisconsin and elsewhere. It's an extraordinary challenge, and I'm not sure that one can say that there is total opposition to it or that there is total welcome for it. It's a much more complicated story, I think.
I think we need to stop. Thank you so much.
Thank you.
I think we can probably unhook you.
Yeah, probably switch this off.
Yes. You can't.
I
Yeah.
figured it out. Okay.
So again, thank you, Raj.
Thank you very much.
I think adding to this community's understanding of these issues in very important ways. And before we close the events today, I'd like to again welcome Dr. Gordon and Feluke up here to close out our program. Quick, thank you.
To Dr. Rajagopal, to the Dean, and to you here gathered. Good afternoon from the Lamar and Gordon families. I am Carolyn Gordon, Valerie Gordon's sister, and I am just really honored to be here. It has been 17 years, and I remember when Val was a student, I actually came and sat in a class with her and realized it was her calling and not mine. It's always amazing when I come back and realize who my sister was and what she did. And you all knew her as Valerie. I knew her as Nisi, her middle name. One of the things many of you don't know is that she was an urban fellow before she came here, so she had her master's of public administration. And when she came here and when the students of color got together and they decided to do this grand walkout, you all saw her walk out. I got the phone call afterwards, okay? Her half afraid to death, wondering if they did the right thing, knowing that it was a necessary thing. And we just talked and said, well, you know, you can always go back and do public administration. But her love and her call was here and human rights. And so I do want to just thank you all for continuing to honor her memory, but not so much her, but the whole idea of human rights. Because she lived by human rights and literally she died from lack of them. And so in case you don't know the story, one of the things is after she had her only child, she had fluid in her lungs, but they dismissed her from the hospital without running any test or doing any kind of x-ray. And so consequently, 2 days later, she ended back in the hospital with double pneumonia and acute respiratory disorder. And we know it's just because she was not giving what she needed to in order to maintain. But in the response from it, we are grateful for her life and how quickly she lived it. I remember when I was at MU and she was in journalism, again, she would come knock on my door. Her first article for the paper was a 4-letter word, girl. Okay, and raised the question, why are women still called girls? Well, the women got mad at her who liked being called girls. Her second article was raising the question about happy hour at the local bars and how our happy hour was actually designed to get women in at a lower rate so the men would come in. So the second time she comes to my room hiding because she's getting death threats from the bar owners. You know, and I told her, look, I don't mind dying with you, but at least confer with me before you write these things. And so it just made sense that she would come here and stir the pot. And my challenge to you is keep stirring the pot. Keep stirring the pot. Some people will be upset. Sometimes you will be afraid. But stuff like this happens because people are willing to stir the pot. So I commend you on your calling, your lives, and what you do. Live it out the best way you can. And just know that even as you study here and as you practice here, as you write here, there are the rest of us who are benefiting from your work. And we are cheering you on, even though we talk about you really bad sometimes. We're cheering you on. So please continue to do what you do because the world is waiting for you. Val's last dying breath was naming him her greatest gift to the world, besides what she's done here, was bringing forth Feluke. And so he's going to say hello. He's not feeling well. But again, we do want to just say thank you.
Just want to say thank you, and it's a great honor for me to be here to honor my mother. And I just really love coming here when I can and experiencing this. So thank you.
By the way, he just got a full scholarship to Indiana State. He's graduating in May, and he's actually planning to play football and get a doctorate. So we're glad to hear him, proud of him.
Even in the years since I've been coming here to see Feluke grow into the son, I know both Valerie and Chris would be and are incredibly proud of. It's an honor to have you here with us and to remind us about who we are and who we would like to be. Thank you all for coming.